They're going to record.
Okay. Well, you can still present his case. We should establish a record. Yeah. I think you're right. But can we do it without them showing up? She can show up to say, I do this.
Just don't want to recall it.
I mean. Very well said. Yeah.
You know, I get it.
All right, we will come. We will now come back to order and be in session, and we will have our closing statements. We're going to ask Mr. Meyer if he would come to the podium and give his closing statement, and then after he has given his closing statement, then Mr. Tyler will be entitled to do the same. Okay, sir. Oh, can I say before this, we're back on Zoom, so sir, you may now go back to recording. The recording is open because we're out of separating our witnesses, so it's open recording. Thank you, sir.
Thank you. Good afternoon. So the question before the board is whether Brandon King lives at 1735 Elson Way. It's pretty clear that if he doesn't, that he's been registered there, he's been voting there for years, and that he would be then ineligible as a voter. And I think that the evidence is sort of interesting to combine his wife's testimony with his testimony. The documents play into it to some extent because they show kind of a history of where Brandon King and Mrs. King have said they lived. But I think when you combine Mr. and Mrs. King's testimony, I think that it is extremely implausible to think that they've been dating on and off for 13 years. They chose to get married in 2022. But they've never lived together. Now, some couples before they get married don't live together. Some do. But it's very unusual for a couple, especially in the same city, not to live together. Now, there's long distance relationships. My son is in one, he's in Pennsylvania, his spouse is here, and they go see each other on weekends, but that's because of their job and school situations. They're asking you to believe as if it's just the normal thing that she lives in Euclid, just down the road from East Cleveland, and he lives in the house with his hoarder brother, where there's been junk, if not blocking, then mostly blocking both entrances for years, progressively worse. He doesn't, Sheldon King doesn't eliminate the hoarding, he just rearranges it, according to Brandon King's testimony. So why would someone choose to live in, as the neighbor said, Mr. Alford, probably the worst rundown house he's seen in East Cleveland, when he could live up the road with his wife, the house that she lives in and that he had some connection to for business purposes going all the way back to 2007, and that he knew the owner of. Now, I suppose that such a relationship would work temporarily for a short period of time, but Mayor King is the mayor of East Cleveland. He's going to be for at least the next several years, and it just defies believability that he's living in that house on Elson, that he's not living, I'm sorry, that he's living in that house on Elson. And if you notice, there was an evasiveness about his responses. Whenever he was asked where he lived, even by his own counsel, he kind of went back to the statutory language. That's his permanent place of residence, his personal place of habitat. And every time he leaves, he intends to go back. And Mrs. King, whose registration, by the way, for 6 months was at Elsinore in East Cleveland, suddenly changed it to her proper address in Euclid last week, which was probably a brilliant legal maneuver by Mr. Starr because it got her out of this hearing. And the problem is that Mr. King can't do the same thing because then he wouldn't be eligible to be mayor of East Cleveland. And that's what this is all about. You have to live in the city of East Cleveland to be the mayor of East Cleveland. And Mr. King has maneuvered and used evasive language to convince this board that he lives on Elsinore in East Cleveland. And it's not as though there's some dispute about the condition of the house. I mean, there's some dispute, I guess, about whether physically you can enter the front door or the back door. Maybe you can, maybe you can't. But it's certainly, based on the pictures and even on Mr. King's own testimony, is an eyesore. And Mr. Alford also testified that it's even creeping over onto the other side of the street onto his property. And if the board believes that Mr. King and Mrs. King have never lived together, they only spend weekends, some weekends together, but never any longer. And if you believe that Mr. King doesn't even remember if he has a toothbrush at Glenruss, the things that he said he didn't remember because he's under pressure are frankly staggering. He couldn't remember when he remembered when he last spent an evening there, which was this past weekend, I guess. But he couldn't remember virtually anything else. And Mrs. King, if you were going to evaluate one's demeanor in how she testified, when she was asked the direct questions about whether she lived with her husband, there was the constant looks over to her attorney. Not one, but two. And the constant objections, because basic questions that are at the heart of this hearing, they don't want you to know. If this was an easy matter of course I live in East Cleveland. Of course I live separate and apart from my wife. Then I don't think that we'd have had all these procedural motions and even the question by question objections, because it would be very obvious. The whole purpose of Mrs. King's testimony was to not answer directly the questions of where she lives and where her husband lives. All this business about spousal privilege. And Mr. King, again, has very selective memory when it comes to when he spends time at MLS, whether the time he spends there would rise to the level of living there. And the lack of memory about such basic things about whether he's got belongings or toiletries at the house on Glenrose. So I understand that the challenger's burden is high, but I think that this board also has an obligation to not only get to the truth of where people live, but make decisions about the credibility and plausibility of the evidence they create. If it was as the Kings said, this shouldn't have been that difficult. It should have been like pulling teeth to get straight answers. As far as the rest of the documentation, the photos, again, the board can take them for what they're worth as far as the evidentiary value, but what Mr. Brewer has put together is a package of evidence of other governmental documents that Mr. and Mrs. King have filed for official purposes that really call into serious question the story they're telling before this board. That they don't live together. And when I asked Mrs. King why she changed her address with the board last week, she said something to the effect of that the previous address was to send stuff to for business. At which point Mr. Starr quickly stepped in and stopped her from clarifying. Mrs. King never lived on Elsinore, but she put down that she lived there for voting registration purposes. And hearing from her, she quickly changed it to her real address. So you've got a kind of a credibility issue right there. And had this hearing not been scheduled, and without the clever lawyering of Mr. Stark, I don't know whether she would have changed her address. Don't want to speculate about that, but it's telling. It's very telling that she said, "I'm going to switch my address from a place I never lived to a place where I currently live." And when I asked her about whether she intended to live in East Cleveland, she said, "Yes, we're going to build our dream house, not on Elsinore, but on like Oak Knoll or some other street." So she's going to build a dream house somewhere else in East Cleveland with a man she's never lived with, but has been married to for a year and a half, having never lived in the place where she registered to vote. And I think that the board has to seriously consider the credibility of the witnesses and why they're doing it. It's not just a matter of, well, you know, okay, so from now on, I'll vote at this elementary school instead of that church. It's a very careful and practiced set of misrepresentations for a very specific purpose, to fool this board. And I would urge the board to not fall for it, to think about all the things that they didn't say, that they were prevented from saying, that they said improperly or contradictorily and rule that Brandon King is not eligible to vote from 1735 Elsinore. Thank you.
Thank you, Mr. Myers. Mr. Tyler?
Thank you. I'm Dr. Charles Tyler Sr. It's been my privilege and pleasure to represent Brandon King. Some 25 years ago, I was on the campus of South Carolina State University in Orangeburg, South Carolina, as a senior waiting to graduate. Dr. Letharius Goggins came to Orangeburg, among other Southern states, to recruit many of us to attend graduate school in Ohio. Once getting to Akron, Ohio, we met every week with Dr. Goggins, and one of the things he would always say to us every week, keep the main thing, the main thing. And today I'm asking that that's exactly what this board would do. Keep the main thing, the main thing. Sure, there was evidence about hoarding, about rundown properties, but this board, that's not your lane, that's not your jurisdiction. That's for the city of East Cleveland. This case is about where Brandon King lives and has his permanent residence. Now, counsel said their story is just not normal. For many of us in this world we live in, people do a lot of things just that's not normal for us. For someone to find their mate on a place called eHarmony, that's not normal. I'm old fashioned. I met my wife at the church. We continued dating. We got married. We lived together. Later on, I became a pastor, a Methodist pastor. My bishop sent me to Columbus, sent me to Pennsylvania, sent me Erie. And there were times, because my wife was a school teacher, we needed to keep our base. So she and my children lived in Akron, Ohio, where she's a kindergarten teacher, while I traveled wherever my bishop sent me to pastor. For many people, that would not be normal. But for me and my wife, it was okay. What I believe is that normal is a relative term that encompasses different meanings to different people. If you want to know what normal is for an individual, you have to ask that individual. So what was normal for Brandon King and his wife? I give it to counsel. That might not be normal for him, but that does not make it wrong. This is same skit, different cast. The last skit was Eric Brewer versus Jeffrey Johnson, right before this committee. This committee lawyer argued before the Supreme Court. Mr. Johnson testified that he was married and that his wife and stepchildren lived in Twinsburg, Ohio, at a separate residence from the residence in Cleveland, Ohio. Mr. Johnson also testified that he had lived at the residence in Cleveland since the marriage and that he had voted from that residence in every election since his marriage. Mr. Johnson provided utility bills, property tax bills, and other documentation to prove his residence in Cleveland. He testified that the residence in Cleveland was his domicile and fixed habitation and the place to which he always intends to return, regardless of the current residence of his wife and stepchildren or the result of the Cleveland mayor primary election in which he was a candidate. This board said in their argument, in his argument, Mr. Brewer focused exclusively on the factors set forth in RC 3502.03D to determine Mr. Johnson's residence. RC 3502.03D states that the place where the family of a married person resides shall be considered to be the person's place of residence. Mr. Johnson cited to this court's holding of State versus Morris versus Stark County Board of Elections, that in determining a person's residence, one clause in RC .350202 cannot be given greater weight over another since all of the clauses are phrased in mandatory language. So he spent all his time focusing on one. But what the law requires is that you focus on all of them because it's mandatory language. He talked about what Ms. King said, what Mayor King said, Well, we know Law School 101, the burden today was on the challenger. They did not have to help him prove his case. In the case of Eric Brewer versus Jeff Johnson, this board said Eric Brewer seeks an order from the court invalidating the decision of the respondent, Cuyahoga County Board of Elections, and ordering the Board of Elections to fine Mr. Johnson in violation of RC 3503.07. Eric Brewer also strangely requests that the matter be referred to the Cuyahoga County's prosecutor's office to determine if the members of the Board of Elections violated RC 3599.16. Again, same skit, different cast. Mayor King have testified here today just as Jeffrey Johnson did. Realtor, Mr. Brewer, according to the brief you all filed with the Supreme Court, Mr. Brewer is improperly attempting to control the discretion of the Board of Elections in this matter and seeks an order from the court directing the board on how to rule in connection with Brewer's residency challenge, which is improper or mandamus. Same thing here. Mayor King testified there was a recall election that failed. So now they come to the Board of Election. The Board of Election is not for political theater. It's not to help people win political challenges they lost in the community. The Board of Election is governed by statute. In your brief to the Supreme Court, it says Brewer is simply unhappy with the board's decision and attempting to undo it through an improper mandamus action. Same here. He's unhappy that the failed attempt to recall the mayor didn't work. So now he comes here before you all, asking you all to help him get rid of the mayor. It was too late. But on yesterday, around 4 o'clock, he sent out an email to everybody in the city saying, hey, as soon as we win, we're going to swear her in. His counsel said, why are they doing this? The question is, why is Mr. Brewer doing this? Every time he fails politically, he comes to this board asking the board to help him achieve what the people don't believe he's fit enough to have. What you argued was Mr. Brewer's entire claim is based on his erroneous application of only one subsection of the applicable law regarding residency challenges. Mr. Brewer has ignored the applicable law and instead attempts to focus on the subsection of the statute to make his claim. However, as is clear from the statute, there are multiple provisions to be considered in determining a person's residency. In election cases involving residence issues, the court applies RC 3503.02, State versus Stein, Brown County Board of Elections. It states in pertinent part, all registrars and precinct election officials in determining the residence of a person offering to register or vote shall be governed by the following rules. And I will not bore you and read all these things because I'm very sure you're familiar with these things. And again, it's a long list going from A to I, and all those things must be considered. And today, Mr. Brewer failed to deal with all these things that are mandatory for this board when they're considering someone's residency. The court has held that the statute emphasizes the person's intent to make a fixed or permanent place of abode. Residence means a settled or permanent home or domicile and includes the fact of abode and intentions of remaining. Interwoven through the definition of residence is a myriad of cases, is an element of intent to return to settle abode. They make a big issue about whether or not he lives with his wife. The statute doesn't require that he lives with his wife. In fact, the statute makes clear, even if he lived with someone, she lives someplace else, it doesn't determine his intent. It's about him. They spend a lot of time talking about his wife, but this case is about Brandon King. While RC 3503.02D identifies a particular circumstance that determines a person's residence, which would seem to make it more compelling than the other factors set forth in section all of our RC 3503.02, including section D, is phrased in mandatory language. So elevating RC 3503.02D over others, RC 3503.02A through C without reasonable justification is impermissible. And that's State Excel Husted versus Bruner. Thus, Mr. Brewer's insistence that the only provision applicable in the underlying residence challenge is RC 3503.02D is simply legally wrong. Mr. Brewer is asking you to force, and this brief, it says that you all said to the Supreme Court, Mr. Brewer was asking the court to force the Board of Elections to apply an improper standard of law to obtain a decision in his favor. The same is true today. He wants to force you to give a decision that's in his favor. Gave you a laundry list of exhibits that nobody testified to, couldn't authenticate most of them because he got them off the internet or someplace else, but yet he wants you to believe he's met his burden. His arguments should be rejected because there's no legal basis to support what he's asking this body for. Therefore, a Board of Elections may not remove a person's name from its list of registered electors upon a challenge unless the grounds of the challenge involves or supported by clear and convincing evidence. Nobody testified here today that they could tell this board that Brandon King does not live where he's registered to vote and where he said. He brought his documents from passports to driver's license, tax returns, everything showing where his residence is. While it is undisputed, the court held in another case very similar to this in Robinson versus Bonds. The court said, the Supreme Court said, while it's undisputed that Robinson Bonds' husband and children reside in Franklin County, RC 3503.02D, that fact standing alone is not substantial evidence from which the board could find that Robinson Bond is not a resident of Champaign County. The board was also required to give great weight to Robinson's Bond unequivocal declaration so stated. Mr. King stated where he lives, his address, his intent, and there was nobody here who could say that that was not the truth. They have to acknowledge it's speculation from what my knowledge is. No one can say that they've gone to that house and he's never there. He doesn't have a bed there. They asked what he had at his wife's residence, but nobody ever asked him, what do you have at the East Cleveland residence? Do you have a bed there? Do you live there? That question was never asked. But the heart of this matter is whether or not he lives there. Finally, even if pursuant to RC 3503.02D, the court said Robinson Bond may have a place of residence in Franklin County, that does not necessarily demonstrate that her proper voting residence is therefore not in Champaign County. When Robinson Bond has selected Champaign County as her residence and the choice fairly confirms RC 3503.02A, only if a showing was made by clear and convincing evidence that Champaign County is not Robinson's Bond place of residence could the board remove Robinson Bond from its list of registered elections. It's not enough to make a big deal that he and his wife don't live in the same place. The burden was with Mr. Brewer, clear and convincing evidence, and the only thing shown by clear and convincing evidence here today is that he failed to meet his burden and the challenge should be rejected. Thank you.
Thank you, counsel. All right, so now it is in the hands of the board for possible motion and discussion.
Are we going to decide decision each person individually?
Yes,
or are we
that's
gonna-
correct, Mr. Musson. We will decide this and we'll go on to the next case.
Correct. We'll call the
Yes.
next case.
Okay, all right.
What is your pleasure?
Okay, I guess I'll go first. A primary question certainly was whether the challenge voter resides where he in this case says he's registered. I am not persuaded that the challenger has met his significant burden of proof. The documentary evidence, which I am including as the marked exhibits today, as well as the administrative record, lead me to conclude that the challenge should be denied. There was quite a bit of evidence about the exterior of the house, but not enough evidence to council made mention of the fact of, what's in the house. Is there clutter and debris on the exterior? Yeah, I think the pictures do indicate that. We had testimony around that. But we didn't have enough evidence that, to me, there was rebuttal evidence to suggest that he is living there. That's his intent to always return. It sounds to me that this is a homestead based on a family homestead, a family house. We have folks that don't live with their spouses. There was evidence around that, but again, that's not for me to decide how the marriage should work, or whether folks should live together, and it's their normal to figure out. So I didn't find that testimony to be probative. I was concerned about some of the coaching around the witness's testimony, that would be Mrs. King. But ultimately, the testimony that was most persuasive was Mr. King's own testimony, and the fact that we did not have any evidence to suggest that he didn't live there, to me, beyond the clutter on the exterior of the house. And what was persuasive for me from the rebuttal testimony was Mr. King's presentation of the indicia of residence that the statute also speaks to. I mean, there were numerous documents that showed his passport, his bank records, his credit card records, his tax returns, all of which had the voting residence on them. The intent to return standard is a difficult one. I mean, we cannot get in anybody's head to say, they're never going to return, or they're not going to return. And I don't recall, Council Musson, that we have any cases where a court has ever said, staying away from your permanent fixed abode for 2 years or 8 years or 10 years, or for the time you're in office, or any of that, weighs in on the factor or affects your intention, your stated declaration to return. And I think that Mr. King was unequivocal almost. I mean, he must have said it 10 times or 20 times that this is where he lives, and this is where he intends to return when he's not there. It is difficult for the challenger. I mean, there is some evidence that caused me to pause, and and I'm not going to say that this was an easy determination for me, because when you look at the structure, it does appear in some of the pictures that their egress and ingress may be impeded. But beyond those pictures, I have to look at the evidence as a whole. And when I look at the documentary evidence as well as the testimonial evidence, I don't believe that there was sufficient evidence for the challenger to meet the clear and convincing standard. And so for that reason, I would move that the challenge be denied, and there would be no change to the registration records in the case of Brandon King.
The motion is properly before us. I will second it for the purpose of discussion. Thank you, Ms. Chappelle. Again, I believe that both sides adequately argued their case, but for me, the understanding of this case was very narrow. Does the person being challenged reside in that location? Now, there's a lot of circumstantial evidence that was presented that could call that into question. However, Mr. King did sit here under oath, and I emphasize under oath, represent that 1735 Elsinore is his permanent address. And as Ms. Chappelle astutely noted, the indicia indicated that. There's a high threshold that has to be met in order to have these type of challenges. We do not know what the interior of this location is. We don't know whether people are coming in and out of there at 2, 3, 4 o'clock in the morning. We don't know that. There's a lot of circumstantial evidence that that was presented that we can't dig into because we don't have access to that. So for that reason, as it was pointed out, there are some irregularities that were highlighted, but that's not up to us to decide on those irregularities. It's up for us to decide whether or not the threshold's been met to appropriately challenge the registration in question. And for that reason, I will support Ms. Chappelle's motion. Okay.
I concur with those comments. I find that the intent to return is it's hard to argue with. Who's to say? The family owns the home, be gone for, gone for periods of time and come back. So I don't think the evidence proved that that was not the case.
It just, in my analysis of this, there's statute, there's case law, there's precedent. We've had this issue before us before. Certainly, I agree with my colleague's statement that there was a lot here to give pause and concern. That's why we have this hearing. That's why I think the claim was brought. Certainly, the picture of the property, it is concerning if there's ability to get into the property or not. But those were exterior photos, to her point. So initially, we look at Ohio Revised Code 3503.02, which we've referenced, which does speak to that intent to return. Doesn't say you have to live there every day, every night. You can live elsewhere on weekends. It's pretty clear. It focuses on the intent to return and people possibly living temporarily elsewhere, but having again that intent to return. So there was evidence presented from Mr. King regarding that intent to return. Additionally, there's factors I know we've looked at before, which my colleagues have referenced, which can go beyond even the intent and the testimony heard. That's the case, I believe it's McPherson versus Trumbull County, 2011, Ohio 1296, that I personally always look at and think about when we've had these challenges before. And it's looking at factors like, and I guess to Mr. King's favor, or in his favor, I should say, the submitted bank statements, the driver's license record, the passport, I believe, tax statements, additionally, even a bank statement. Those are listed factors in this case of things that a board can look at when determining intent or residency in this instance. And now other factors which were also listed but not necessarily given greater weight were where the family resides, if the family resides elsewhere, which can be looked at, which was, I think, by this board, the fact that there is a spouse, the fact that she resides elsewhere. But additionally, there's not required that spouses live together. Certainly, we've seen spouses that don't. And additionally, too, there's talk about them potentially moving somewhere else. So while that is a factor that would cut against Mr. King, I think if you look at the other factors and the statute, that's what gives me pause. Also, there was discussion on the day-to-day personal items. The reason why that is important, that is also a factor to look at. I did find it unusual. I couldn't remember where a toothbrush was kept. I did find that, but there wasn't really a development of what's inside the home. And that is something, again, to weigh and factor. So given all of that, I do think that while there are some questions here, I think given the case law, the statute, and the factors, I would conclude with your motion.
Thank you.
Agree, I should say.
Concur.
Concur, yes, thank you.
Okay, thank you. The motion is properly before us. Is there any other unreadiness?
2 seconds.
Yes,
Oh,
I
yes,
second,
yes,
yes. All right, all in favor? Aye.
Aye.
The ayes have it. It is so ordered, and that challenge is denied. Okay, we will now call the case for Norma King, Hassani Week. Order, you may leave silently. We now have the case for Norma King. Mr. Wheat, the floor, sir, is yours.
Thank you, Mr. Chairman. You should have before you a challenge that was submitted to you by Mr. Eric Brewer. On April 17th, 2023, Mr. Brewer, a registered voter in Cuyahoga County, submitted a Secretary of State prescribed form 257, challenge of the right to vote and correction of registration lists on Mrs. Norma King, who is currently registered at 1735 Elsinore Avenue, East Cleveland. According to the voter registration card that is on file for Mrs. King has been registered at 1735 Elsinore Avenue since September 23rd, 1976. The voter registration database also shows that Mrs. King has voted at the Elsinore Avenue address since the November general election in 1990, a total of 47 times. The voter registration database also shows that there are a total of 6 individuals that are currently registered at 1735 Elsinore Avenue.
Thank you, Mr. Wheat. I will now call Mrs. King. Is she available? Ms. King, do you have counsel now?
No.
No counsel. Okay. Well, we will swear you in, have our court reporter swear you in, and then we can hear your testimony.
Swear or affirm that the testimony that you say will be the truth, the whole truth, and nothing but the truth. Speak up.
Yes, please.
Hold on.
Sir, witness has already been sworn in, but we need you to go first so you can present your case. I got ahead of myself, so.
Yes.
So you can present your case, Mr. Myers, and then we have a witness. She's already pre-sworn. If we need her, then she can just come back up to the case. So it's your,
She needs to stand there. She has-
Mrs. King, if you would offer her a seat, please. Yeah. Thank you.
We don't need her to stand there. Mr. Myers, the floor, sir, is yours to present the case. And then if you choose to call witnesses, you may do so. Thank you.
Mrs. King, testify or? should I
It's up
call
to
her?
you if you want to call her.
Yeah, call her.
Yes, okay.
I saw her up there, then she wasn't. so.
Okay. Did you want to give an opening statement?
Yeah, do you want
Yes,
to
you can give an
briefly?
opening statement. yeah.
I'll just reiterate the, or let
Excuse me,
Ryan.
let me interrupt, Mr. Chairman. Must this part be recorded? We would like the same courtesy where it was not recorded.
Do
Oh,
we-
yeah, the,
Yes, we can,
Yes.
we can end the recording, yes. Mhm.
for the purpose of separating the witnesses.
Right.
Or if we have more
If
than
we have more than.
Is it just the one
Or
witness?
you just call
Yeah,
the
there's no
one.
other